Hello everyone. So in this video we are going to see on UPSC 2025 polity questions. So there are totally 17 questions we have. Okay. So first question, with reference to the Indian polity, consider the following statements. The governor of a state is not answerable to any court for the exercise and performance of his power or duties. No criminal proceeding shall be instituted against the governor during his term. So both are good. Okay, both are true, and it is given under article 361. Okay, where it gives you the protection of president and the governor on certain rights, and both are true and according to 361. The next statement is members of state legislature are not liable to any proceedings in any court in respect of anything said within the house, and this also holds good according to the article 194. Okay, so all these three statements are right. We will see each article now. The first article is 361 under part 19, where it says about the protection of president and governors. So where the president or the governor shall not be answerable to any court for the exercise of his duties, and the no criminal proceedings should be instituted against the president. And remember, all these statements are direct statements from the articles. So from this we understand what is the importance of reading the article line by line and remembering these things. Okay, and majority of the questions are in this way in this UPSC exam. The 194 article, where it deals with no number of state legislatures will be liable to any proceedings in any court. Okay, right. The next question, when this following statements they have given three statements. The first statement is list 1, which is a union list in the 7th schedule, extent of the executive power of the state, and third is the conditions of the governor's office. Among these three, which of the constitutional amendment, that is if you do a constitutional amendment among these three, okay, which will has to undergo a ratification by the state legislature, by more than one half of the state legislature, to get it as a bill to get passed into the president for his accept. So that is what the question is. So for which of the constitutional requirement it requires the ratification of the legislature by one half of the state. Among this, we will see each statement in detail, or we will see in the other terms what are the things where this ratification is required. So the ratification is required for these things, okay, which is all given under amendment of the constitution of by the article 368. It is given under part 2 about these three. Okay, so first is here these articles 54, 55, 73, 162, 241 and 279A, and the chapter 4 of part 5, chapter 5 of part 6, or the chapter 1 of part 9, part 11. Any list in the 7th schedule, representation of states in the parliament, and the provisions of this article. In this article itself, that is provisions of in this article in a sense in the amendment article itself. Okay. So the article 54 was dealing with the election of the president, 55 is the manner of the election of the president, 73 is extent of the executive power of the union, 162 is executive power of the state, and 241 is the high courts for union territories, 279A that deals with the GST council, and then the judiciary, the both the union judiciary is Supreme Court and the High Court. Okay, so that is a chapter 4 of part 5 and 5 of part 6, all these two things. And finally the distribution of the legislative powers between the union and the states among the chapter 1 of part 11 from 245 to 255. Any changes in these articles, okay, along with the 7th schedule, representation of the states in the parliament, changes in this article itself, it is 368 itself. For these things you require an amendment of the constitution by the ratification of one half of the state legislature majority. Okay, so among this we have seen, so now we can see these easy statements. So list 1 union list in 7th schedule, yes, we have seen. Next one, the executive power of the state, yes, we have seen on this under article 73. And conditions of the governor's office, yes, this statement is not seen among these three, so these two is right. So I think 1 and 2 is the answer. Which is the next question. Okay, with reference to following pass, which of the following thing is correctly matched? Okay, so National Automotive Board. So we know automotive means itself is a vehicle. So vehicle will always be there in a heavy industry. Coir board is nothing but the maths. So the maths, everything will be going into small industries. Then you have trade. So National Center for Trade Information. So it is always with the commerce. So all these three statements are wrong statements. So nothing is correctly matched. The next is with reference to the Constitution of India, if an area in a state with this declared as a scheduled area under the 5th schedule. 5th schedule is dealing with an SC/ST areas of the state. So the state government loses its executive power in such areas and local body will assume the total administration. Is this true? No, because the state government will never lose its executive power of the state, even though the local body has its own power in certain aspects, but still the state government is responsible for certain things in the particular areas, which is detailedly given in the 5th schedule. So, and the union government can take over the total administration such areas under certain circumstances, recommendations of the governor. Okay, so this is nothing but what they are trying to say in the statement is nothing but your president's rule. Like a state can be taken or control by the president whenever under a president rule, but the local area alone cannot go into the president rule. The local area can get into president rule only if the whole state gets into the president rule. So only the governor, without the whole state getting into president rule, the local alone cannot get into the president rule. So this statement is also wrong, because they say the total administration will go into the union government if there is a president rule the president rule is recommended by the governor. But that is not true, because only if the whole state goes, the local area also goes into the president's rule. So both the statements are wrong. So both the statements are wrong statements. So this we can see now. Okay, right. Next question is, again we have to see what are the patches correctly matched. And this is a very direct questions where we know all the threes are directly matched, because the active principle of state policy, separation of judiciary and the executive is right. And rich heritage, composite culture is a fundamental duty, and employment of prohibition of employment of children less than 14 years of age is a fundamental right. All these three statements are right, so we know it is correctly matched. The next question is, consider the following statements where the Constitution of India explicitly mentions that in certain spheres the governor of a state acts in his or her own discretion. Okay, so in certain spheres the governor can act on his own discretion. That's what they say. So this is explained by the article 163 that you will see, which is nothing but the Council of Ministers to aid the governor. In that it has been given one statement, which is he has to act in accordance with the Council of Ministers statement, but in certain conditions, except in so far under this constitution required to, when the constitution requires him to exercise his function, he can act on his own discretion apart from the Council of Ministers. Okay, so this statement is right. The next is, president can of his or own reserve a bill. The president itself can reserve a bill passed by state legislature without the forwarded by the governor of the state concerned. Okay, so without the governor passing the bill to the president can withhold this tax. That is what they say. I think this is not given in the constitution, because only when the governor can pass a bill to the president can give his assent or he can withhold the assent. But it can be done to the state bill only if the governor passes the bill to the president. If the governor doesn't pass the bill to the president, the governor's decision is the thing that is happening, and that also is with many ifs and buts and discretions. So this statement is a very wrong statement, because president cannot reserve his bill without the involvement of the governor. So the only correct statement is one only. The first statement is alone correct according to the article 163. So which article that is going to deal with the accent to the bill by the president is 200. Okay, that is not easy. So accent of the bills. So governor shall declare either that he accents to the bill or withholds the accent therefrom, or he reserves the bill for the consideration of the president. And when the bill is going for the consideration of the president shall declare either that he accents or he can withhold, but only when the governor. Okay, that is the important point here discussed. So next question is, with reference to India, we have to consider these three councils. So among these three councils, which is established by the Constitution of India. So we will see about these three: Interstate Council, National Security Council, and Zonal Council. So the only one word which is mentioned in the Constitution is this Interstate Council, which is mentioned in the Constitution under Article 263. Okay, it's nothing but the distribution of powers between the Union and the states. So in that particular thing, in the 263, that gives a provision for interstate council. Okay, but what happens to the National Security Council and the zonal councils? So National Security Council is neither a constitutional nor a legal statutory body. Okay, it is just established by the Cabinet Secretariat in 1998, which to advise the President on the security issues. So it's neither a constitutional nor a legal body. The Zonal Council is not a constitutional, established by the constitutional body, but it is established by the statutory body, which is not mentioned in the Constitution because it is established under States Reorganization Act, so it becomes a statutory body. Okay, so among this, only the Interstate Council is been established by the Constitution, the other two is not. So the only answer is only one. The next is you have to consider the following pass and which is correctly matched. Always when you answer a question, always first read about whether it is correctly matched or it is wrongly matched. Then it can be very easy to answer the question. The first statement is Arunachal Pradesh. The capital is named after a fort. You know what is the capital of Arunachal Pradesh? It's Itanagar, which is actually named after a port, and it has two national parks. Yes, it has two national parks, which is namely Namdapa, Maule. Okay, it has two national parks. So now what happens? The second statement, Nagaland, just comes into the existence on the basis of the Constitutional Amendment Act, and there was a lot of confusion whether this is a Constitutional Amendment Act or not. So initially, the Nagaland is usually formed from the States of Nagaland Act 1962. So that is the first thing where the state has been formed by which was an act of a parliament. But again, there is a Constitutional Amendment Act which gives a Constitutional Amendment for this at 1963. But after that, only the state has formed. So the 13th Constitutional Amendment Act actually deals with the state of Nagaland. Hence, we can take this statement as a right statement, even though the state has been formed before the Constitutional Amendment Act itself by the State of Nagaland Act of 1962. But still, it is 1963 Constitutional Amendment Act is there for the state of Nagaland. Hence, the statement is right. The third statement is Tripura, where initially it's a Part C state. It has become centrally administered territory with the reorganization of states in 1956 and later attained the status of full-fledged state. Yes, it is right. So initially in India, it was divided into A, B, C, D category states. So among this, the C category state is a Tripura, and then becomes a full-fledged union state in 1972. Initially, it was a union territory. So additional information on the Amendment Act which passed in the year and the states has been formed from this Amendment Act. So Sikkim, which is formed from 36th Amendment Act, Goa, Daman, Diu on 56th, Mizoram on 53, Arunachal Pradesh 55, and our Western Nagaland at 13th Amendment Act, Jharkhand, Chhattisgarh, Uttarakhand at 56th Amendment Act. So this is just things that you should remember. So the answer for this question should be all the three is correctly matched. The next question, with reference to Indian polity, we have to consider the following statements. This is also a very tricky question. An ordinance can amend any central act. An ordinance can abridge. What is abridge? It can violate the fundamental right. An ordinance can come into effect from a back date. For example, our ordinance has come now. So before it can back date to 2 or 3 months or 2 or 3 years earlier. That is what they say. So all these three statements we have to see which is right and wrong. First, we have to know what is this ordinance. Ordinance nothing but the president will promulgate this ordinances when the parliament is not in the session, and it has to be approved by the parliament within 6 months or its next session to become into an act. That's the order. Ordinance nothing but a temporary law which is made by the president, but it has to get approved only by the parliament within 6 months. If not, this gets outdated. That's what this constitution says. So now this can amend any central act. Yes, it is similar to that of your laws or the bills. So you can amend any central act. That is a very true statement. Okay, because it is by the president itself. Okay, the one thing that is going to be different, it can backdate. Yes, because this is similar to that of a law. It can even backdate to any date. Both these two are right. The other question arises is whether this second statement is right or wrong. So for this, we can consider under Article 13. So what does this Article 13 says? That's something about the fundamental right. The state shall not make any law which takes away or abridges the rights conferred by this part. So the state will not make any law which is going to abridge the state. So a law cannot be formed. Same thing, an ordinance cannot be formed. So the statement is a wrong statement. Okay, so the statement answer has to be 1 and 3 only. That should be the right thing for this. Okay, so you have to remember this Article 123. So where it is the power of the President to promulgate these ordinances and the House is not in a session. Okay, next 18th question is consider the following statements. If any question arises as to whether a member of the House of the People has become subject to disqualification under the 10th schedule. What is this 10th schedule? Is nothing but the anti-defection law. That is without changing it. That is, if the person that changes his party is going to lose a seat. But there are certain limitations. But that is given under 10th, that is anti-defection law. So, if a member of the House as People has become from the Lok Sabha, then it has become a subject to disqualification, which is under this 10th schedule. The President's decision in accordance with the opinion of the Council of Ministers shall be final. But the point here, the very trickiest word is President. Okay, yeah, that is the thing that is going to confuse everyone here. Under 10th schedule, we have this member of the House of the Lok Sabha, where if a question arises and whether he should or should not, whose decision is final? It is the Speaker's decision is final of the Lok Sabha with the consent of your Union of Ministers. But the Speaker's decision is final around this. Is not the President, because President has no role in this particular regard. But what happens if the Speaker itself is in the anti-defection law? Then a person who is nominated by the Parliament, the majority, he has to decide based on the Council of Ministers advice. The second question is, there is no mention that there is a political party in the Constitution, which is also a very wrong statement, because all of the 10th schedule is dealing with the anti-defection from one party to the other. So there is a mention of political party under this 10th schedule. So both the statements are wrong statements. And again, you have to see it's correct or incorrect. So we can see this is given under 10th schedule in anti-defection law. So it's a decision of the chairman, or in the case maybe the Speaker of the House shall be the final. That's a very important thing. And the next thing, there is a mention of this political parties here in the 10th schedule. The next question is, consider the following statements. They are given two statements and they ask whether these two are related or not. So first statement is, in India the state governments have the power, no power for making rules for grant of concessions in respect to the extraction of the minor minerals. This is again, UPSC is playing with the words. This is about the minor and major minerals. You have to know what is the differences between this minor and major minerals. We have some minerals is categorized as minor and major. This categorization of the minerals, okay, is done by the Union government, and Union government has a very important say in the major minerals. But for minor minerals, it is the states that has a very important role. The categorization of the minor is done by the Union, but the state has a role to say about the power to make the grants. Okay, so this power is with the states. There is no power. It's a very wrong statement. They have no power for a major mineral, but they have a power for a minor mineral. In India, central government has the power to notify minor minerals under the relevant law, and it is a very right statement. So statement 1 is right, not correct, and statement 2 is correct. We will see that. So this is given under the 857 Mines and Minerals Development and Regulation Act. Okay, so central government is responsible for the major minerals, but the state government is empowered to regulate the minor minerals. Okay, and then the central government will have to notify which minerals are minor and which are major. Okay, the next question, we have to consider all the three statements, amongst which is right and wrong. On the dissolution of the House of the People, the Speaker shall not vacate his house until immediately before the first meeting of the House of People of dissolution. Okay, after according to the provisions of the Constitution, member of the House of People, on being elected as is, he has to resign from the political party. The Speaker of the House of the People may be removed from the office by resolution passed by House of the People by a majority of the members, provided that no resolution shall be moved until unless 14 days notice has to be given. Okay, we'll see these statements in detail. The first statement is a vacation. Okay, vacation of the House. He will vacate if he ceases to be a member, and the main thing is he will not vacate his house until immediately before the first meeting. You can see this is a very direct statement from the article itself. So this is a right statement, and we know 14 days period is also a right statement. Now come to the question, the second statement is right or wrong. So there's no mention of this in the constitution as such, that he should resign from the constitution. He has to be impartial, so only they mean that they will resign from the party, but there is no mention that he should resign or not. So this statement is a wrong statement because there is no mention of this in the constitution. So you can take 1 and 3 as the right statement. The next question, pardoning powers of the president, which is dealing in the article 72. So the exercise of this power by the president can be subject to the limited judicial review. Absolutely can be limited to judicial review. The second is, can exercise this power without the advice of the central government. Again, there is no direct mention of this, but still the president should act on the advice of the Council of Ministers. So yes, this is also a wrong statement. So 1 only is the right statement. We'll see that. So there's a pardoning power of the president. Supreme Court has upheld this in multiple cases, that they have a judicial review of this, so subjected to a limited judicial review. Whereas the Council of Ministers to aid the president is a very right statement because they have to aid the president. The next question is on the Lokpal Act. The Lokpal Act has been passed in 2013 for the civil government servants. So power of Lokpal is applied to the public servants but not to the Indian public servants posted outside. It's a very wrong statement because it applies to everyone. The second is, you have to choose which statement is right. The chairperson shall not be a member of a house or a state legislature, and only the Chief Justice of India, whether incumbent or retired. So again, this is because this is right. So yes, he should not be a member of a parliament or legislature. The thing is, not only the Chief Justice, okay, even the justice who is under this can be taken over the post. The next is, chairperson member shall not be a person less than 45 years of age, which is a right statement which is given there. And Lokpal cannot inquire into the allegation of corruption against sitting Prime Minister. It is a very wrong statement. It can inquire, but it can't inquire in certain circumstances that we will see the next slide. So among this 1, 2 and 4 are wrong statements, only 3 is only correct statements. So you see this under Lokpal Act. So where it gives a chairperson or a member cannot be a member of a parliament or state legislature, but it can be a Chief Justice of India, Judge of a Supreme Court, and any other person who is with the same experiences. Next, it gives a 45 years, unless he is about 45 years of age, he should appoint as chairperson, and the Prime Minister can get into this except in those 4 things where it cannot be acquired. Next is the panchayats. So panchayats are at all intermediate level exist in all states. No, it doesn't exist in all states because it says about only 20 lakh population, more 20 lakh population states should have a panchayat. That's what the constitution says. There are many states with less than 20 lakh population where it is not required, so there is no panchayat in all the states. And to be eligible, he has to be under 30 years of age, which is a very wrong statement because it's just 21 years is enough for a, so it's also a wrong statement. The third statement is, the chief minister of a particular state is not correct. Here says, so it's a wrong statement. So constitutes a commission. The chief minister of a state will constitute the commission. So financial position, it's not the chief minister, it's always the governor who constitutes this finance commission for the local bodies. So it's all given under the articles. So first we do 243B, okay, where panchayats serve for more than 20 lakh population. Next is 243F, where it says about the minimum age of 21 years. 243I, where it says about the financial position, which is by the governor. The next question is with the pairing. So here there is very direct questions. So we will see directly that Minister of Home Affairs is not involved in the enforcement because enforcement is under revenue. All the other statements are right. And final question is regarding the Gandhi Peace Prize. Who's a jury? President is not the jury, is the Prime Minister, Chief Justice, and their opposition. So 2, 3, 4 is right. President is not the, among us, President is not among the members who are going to select. Okay. Thank you for this video, for your patience listening. Thank you.